I mean, it actually really irritates me when commentators talk about the liberal wing of the Supreme Court and the conservative wing of the Supreme Court, because it really shouldn't be characterized that way. It's not a political branch, you know. But judges, I think, tend to, I mean, the way they analyze issues, you have to break them down so much, and they have to always, you know, refer to precedent, and they don't fly by the seat of their pants the way politicians do. You know, it's just different. And it's part of the reason I like working with judges, and I like working for the judiciary, is because of that amount of reflection and thought that goes into decisions.
Yeah.
But yeah, no, they can be unpredictable. And then you think about, you sit on the bench with life tenure, and you know, you've got to experience so many different shifts, large and small, in your sort of worldview during that time, I would think. Of course, yeah, I forgot, Will's the one who needs to come from that other class, so we'll just kind of chill for, there we go. Sorry, I was like, just realizing that you have to come from the other class on Saturday, but I'm going to talk to you guys for a few minutes before we're all really excited to understand the article you wrote.
I bet, it's just brimming with excitement, I can see.
Okay, so today, as you know, the agenda is to finish up our discussion of these sort of judicial behavior, judicial philosophy articles, and again, that's serving just as background for our thinking about the role of the law clerk, the role of the judge, and also for beginning work on our problem, which is going to be based on the Proposition 8 litigation before the Supreme Court. And then I want to shift gears a little bit, and we're going to do an overview of some of the jurisdictional procedural issues that you want to be thinking about, and with respect to your clerkship. And so we're going to talk about trial court procedures to a certain extent, and how those mesh with, you know, the transition to the appeal. Mostly going to talk about Colorado Court of Appeals procedure and Supreme Court procedure, but there are analogs for all these things in the federal, at the federal appellate level as well. And so we'll definitely touch on that, but we'll sort of start with the state courts. And so this is obviously kind of a lengthy agenda in terms of issues I want to get through, but we're going to deal with them pretty quickly. And then at the end of class, I'm going to give you the district court decision in the Perry case. I actually was really lucky, well, it was unfortunate because Catherine Smith, Professor Smith, Dean Smith, had to go out of town, and so she asked me to teach her seminar yesterday, and we covered the Perry, the district court, and the Ninth Circuit opinions, and it was a really, really interesting conversation. So I think we're going to have a great time talking about that in this class. And further, we're not just talking about it, we're talking about it as a foundation for the opinion that you're going to draft. So I think it's going to be quite interesting. So why don't we go ahead and get started, finish up our discussion of the articles, and we'll start with you, Will, and move on here.
Cool. Yeah, so my article kind of ties in as well, but it is much different than kind of anything I've read in law school. Instead of being based on opinion or argument, it's tried to break down everything from a numeric, mathematical analysis to come up with basically how the judicial system works and how judges rule. So they looked mostly at two different databases. Something called Spath, named after the people that created them. Spath is one that from 1953 to 2006 kept every judge and how they voted on every case throughout those years. And then the Songer database is the same thing for the federal appellate cases, and they do more of a sampling, not a comprehensive database, but that's from 1925 to also 2006. So a lot of data out there. The formula that Professor Pollvogt referenced yesterday is on page 13. If anyone knows what that means, I am more than happy to learn. But that was actually the formula they used for a lot of their analysis and for a lot of their charts. And
can you talk about the factors in that formula just a little bit?
Yeah, that's kind of where I'm going to.
Okay.
So I actually picked out two tables that I liked out of the ones in the article, but they weren't really based on this formula. They're two different separate ones, but the ones in these formulas are the basis for most of them. What they look at mostly is like who this analysis breaks down basically conservative or Republican or liberal versus Democrat. So the political stance of the judges, who appointed them, usually those are the same. And so it really breaks down, looks at a Supreme Court basis and also an appellate court basis. And so it looks at like whether or not they're Republican or Democrat, also their time on the court, I believe, and then I think like whether or not they were a circuit court judge before being appointed, are kind of some of the major factors. When they looked at the appellate court, they looked at even more. They looked at like whether or not they were a district court judge before. They looked at their gender. They looked at what circuit they come from. They looked at what their race is. And a couple of conclusions that they had were black judges were significantly less conservative, meaning liberal, and then the new appointees were actually much more conservative. And how they usually how they defined conservative and liberal, besides just a political standpoint, was conservative, you affirm the case on appeal. You didn't remand. And then liberal, you did overturn the previous ruling.
And that's an interesting point too, because the conservative has a lot of different meanings, right? So on the political spectrum, it means one thing, but the idea that that kind of reflects a deference or sort of unwillingness to interfere with what the lower courts are doing, which is a different type of conservation of the efforts of the judiciary and what have you.
Yes, definitely. And so, and they definitely are concerned with a lot of like the ideology of these judges, like what their standpoint is, how you're going to frame an argument even to some of them, how a certain court's going to rule just based on their political standpoint alone. So I mean, in some cases you've won before you even submitted a brief, and others you've lost before even getting started. So it's a little bit of a look at that. Let's see what else I have in here. So after they broke down the conservative and liberal standpoints, they then went into three other factors. They call them political polarization, conformity, and group polarization. And so for political polarization, they found that the Supreme Court inhibited this feature, I guess. And what they found was that if there is let's say there's a conservative majority, the political polarization is something that occurs. And what that is that the liberal or Democratic minority will become more boisterous and more opinionated and more outspoken. And the way that they'll do that is through the dissent. So you're going to see more dissents when you have a smaller minority. And
so the more outnumbered they are, the more feisty.
The more feisty they are, definitely. Yeah, that's a great way to put it. But then they sound like the exact opposite for the circuit court. The circuit court, they found that the larger the majority, the more conformity there would be. So the Democrats would move more towards the kind of conservative majority. And then also the group polarization was really similar, where if there's a polarization, it'll, instead of kind of forcing them one way, it almost pulls them towards the group, so that the Democrats will be more agreeable, dissent less. And the big reasoning behind that, I found, was that Supreme Court, they take like a very small fraction of cases. Yeah. It's 1 in 1,000 cases that they'll see on the appellate. So they can pick and choose. The workload's less. They're dealing with a larger constituency, so they have more flexibility to put out these opinions. And whereas the circuit court, I mean, that first right of appeal, and so they'll get a lot more cases. I mean, they're getting way more with less resources, and so they dissent less. I mean, it's more workload. If they're going against the group, and they're dissenting every time, that's more work, they just don't have the time to do it. And so they're more likely to conform and kind of go along with the group mentality.
And I'll just sort of weigh in on that, like thinking about the Vermont Supreme Court versus the 10th Circuit Court of Appeals, obviously it's state Supreme Court, but there's a cost involved in dissenting, right? I mean, all sorts of costs in terms of maybe collegiality, but also certainly time and effort. And I never saw the judges or justices in the Vermont Supreme Court making this calculus, but the judges on the Court of Appeals is kind of like, is it worth it? Like asking themselves that question of whether it's worth it, given the workload, right? And given, the number of different issues that you're seeing on a monthly basis or whatever. So that intuitively, or in terms of experience, actually resonates quite a bit.
And so, and all of their conclusions are based on this mathematical formula. So it's like, a lot of the stuff is pretty intuitive, that you'd almost kind of think, like, okay, that makes sense. But it was like, finally they went through, like, we're going to look at all these cases on a numbers basis and prove this, like, mathematically instead of just on an opinion, intuitive basis. So I found that was the value that supports the argument, but some of the stuff is almost kind of dumb, we already know that.
That is a response a lot of people have to this type of work.
Yeah. And then there's a lot of work for small conclusions, I think. So,
That's great.
All right, so some other little small facts I found in there. I guess some of the stuff like for the conclusions and facts, I was just going to throw them out and ask you guys, just because I kind of want to see your opinions versus how the numbers line up and see if they match or if they're different. So, Alexis. And then if you didn't read or if you didn't get some of these things, even better, because like I kind of want the raw opinion versus the numbers. So just one question out is like Republican versus Democrat judicial appointees for the Federal Circuit Court. Who do you think, which party do you think has more?
Oh, I don't remember, but I would guess Democrat?
That is incorrect. But it's actually very close.
You said it like correct.
Yeah, but it's very close.
That is the second best answer.
That's what Johns will say, yes, that's the second best answer. Republicans, there's been 179 appointed, and Democrats 172. So, I mean, it's actually really equal.
That's
which,
yeah.
I thought was kind of nice to see. I don't know how our presidential appointments or elections pan out, but I thought that was a fun fact of the day. And then you talked about there being like a cost that needs to be considered by the judges, and then another one that it brought out the fact too was for lawyers and for parties to appeal. They could compare basically the results in the federal court in civil cases to the Supreme Court civil cases, but you couldn't really compare criminal cases, and that's because in the criminal case, the losing party is going to appeal almost every single time, and that's going to be at a cost of the government, not coming out of their own party or the own party's pocket. So, so what that reflected was that the merits in the civil cases are much better than the criminal cases. And so once it kind of makes sense, but it's like you don't really think about it. But the numbers definitely reflect that.
So then if we call affirming conservative, that's why the circuits are more conservative, because they're hearing all these lopsided criminal cases.
Yeah. And then they broke out, on some of these tables, they broke out by subject matter. Is it a tax case? Is it a civil rights case? Is it a criminal case? And so they broke into about 6 different subject matters. Just look at one of them here.
Well, so this is a really interesting point that actually ties into some of what we'll talk about later, but intermediate courts of appeal it's not a discretionary appeal. So it makes sense in a sense that there's going to be a lot more affirmances than at the Supreme Court.
Yeah.
So Allison, you won't have to hear any crap cases.
Yeah.
Yeah, there's some truth to that.
So yeah, it does kind of weed them out, but and so it was pretty even as far as like conservative and Democrat. Most of the numbers were like close to 50% or so, or high 30% to 40% with some wish-wash in the middle, but those criminal cases, it was by far very low liberal amounts, because even like the Democratic liberal basis would affirm them time and time again, because just the merits weren't there. They're just receiving all these appeals that were kind of, I wouldn't say meritless, but less persuasive and less strong of a case. So.
But more at stake.
Yeah, yeah. I mean, like some of these are coming from federal prisoners, and not from their attorneys even. So.
Well, yeah, that's. I mean, I've seen pro se, prison conditions briefs that were better than ones written by attorneys, but there's a, again, when it's costless to file these matters, it changes the equation.
All right. I got a couple kind of oddball conclusions too. Is that on the Supreme Court, they found that when there was less Democratic representation for the judges, they saw that like polarization effect, but they didn't really find it as much for the Republicans for some reason. They weren't as much of an outcry as some of the Democratic side. I don't know if some of that is just from home party opinion that you might have noticed from things you've seen, but that was how the numbers panned out too. Is that the Republican judges seemed to kind of dissent or complain less. Let's see. Oh, they looked also as well at the Senate and how many Republican senators are appointed, and that they found that when there's a Republican Senate, it'll actually even persuade the Democratic judges to vote more conservatively. So there's even an influence there, and I don't know. It seems separate, like separation of powers. It should be independent and separate, but somehow the mathematical numbers line up that when you have a Republican Senate, that it persuades or somehow draws Republican votes.
Was it the other way around too? Sometimes it seemed like he would say it one way, but not the reverse, right?
Right.
Did you?
Right.
And
Yeah,
I didn't know why he did that.
Yeah, and I have the note from there, like this is in the conclusion section at the end, that it wasn't conversely true. So if it was a Democratic Senate, it didn't necessarily pull it to be more of a more Democratic Supreme Court.
I thought that was interesting, and I didn't really know why.
Yeah.
Well, if you ever have worked, not that I've worked a lot with these people who are really into data, but it's sort of, you don't know what you're going to get looking for correlations, and so they're probably referring to the strongest correlations where, something seemed to actually make a difference. But
Okay.
which can be kind of, that's sometimes too, I feel like this type of scholarship can be a little random because there's not really a coherent thesis. It's more, this is what I found in the data.
Right.
Yeah, they did kind of massage the data as well for the SPAIF and the SONA databases, and it was probably for the best. I mean, I actually worked at a research and data company before going to law school, and it's so true that like garbage in is garbage out. And so some of this stuff, it's almost like the opinion and arguments are almost a stronger case than some of the numbers sometimes. But they went through the appendix, and for some reason, like every time that an intellectual property case was overturned, it was automatically like a liberal, marked as like a liberal case. But some of them weren't necessarily or shouldn't really be that way. And so they went back and kind of recoded some of the data. Like some of them, like in criminal cases where it's like a white collar case, where the Democrats actually would want more government control, yet the case was overturned. So it didn't really match up. Where like your Democratic Party does want more government control, but it was a remand, so it was actually more of a kind of like a Republican, less government position. So they went back and recoded some of those so that it actually did align with political parties. So that was something that I thought was pretty good. So just taking these numbers at face value, they actually went through and combed through a lot of this data. And then going back to just like, well, my two favorite tables, I guess. Table 11 actually gives you the percentage of votes based on presidency, and tells you from Clinton back to Roosevelt, Taft, McKinley, and Harrison. and everything in between, gives you kind of like the liberal percentage, the conservative, and then like a mixed vote. And you can see how they fluctuate, like, I mean, and then it also breaks out by all cases, civil cases, criminal, constitutional, economics, and labor. And so you can kind of see how the votes panned out. And you'll see, like, once again, criminal is like the liberal criminal votes are way less, like 0.258 versus 0.684. So I thought that one was kind of interesting to compare history. And then before you guys look, my opinion-based section was going to be like, who do you think the most Republican or conservative judges are? And does that line up with their actual mathematical votes and tallies? So just give me 3 Republican
Celebrity judges.
Or names are Supreme Court justices.
Just Supreme Court justices.
Well, I looked at that table and it was what I thought, but
It was?
but it kind of ties into my presentation because of the racial factor.
Oh.
Well, I gave it away, sorry. Anyway.
I'm gonna go Marshall.
Or are you going Democratic or Republican?
So 3 most Democratic.
Yes.
This is not like, this is going back.
Yeah.
Marshall, Brennan, and Blackman.
Blackman? Okay. And then 3 Republicans.
Thomas.
You're welcome.
What'd you say?
I said you're welcome because I accidentally gave it away.
Scalia's not, let's say Scalia. And,
We were at Plessy versus Ferguson.
yeah, how far back did we go?
I know there's so many.
Who's the guy who wrote Walker? Pickman.
From Bill's presentation.
Is he on there?
I don't know who wrote it.
Peckman, maybe? It's like
Okay,
something
let's
like
go with that.
Or Rehnquist, wasn't he?
I was gonna say no Rehnquist.
Yeah.
Yeah. All right. Well, you guys are very smart, so I'll just give you. I'll give you the Republican judges because you've named all 3 of them actually, the top 3. But number 1 was Thomas. Number 2, Rehnquist. Number 3, Scalia. And then Roberts closed out 4. And Alito. But yeah, so it ranks them all, and then from a Democratic perspective.
Now, how far back did that go, Will?
I mean, it has.
Did it go all the way?
30 justices on it. So, I mean, it goes back to
1937.
Marshall.
Really? And still
Yeah.
those guys,
It is
because
interesting,
they're all
isn't it?
current.
Yeah.
Yeah.
Or fairly current.
So
Yeah, I mean, I think it's that database range of like 19.
Marshall,
Yeah.
Douglas, and Murphy.
Yeah.
Those-
Yeah, exactly. Yeah, 1953 to 2006 is the state data, and that's what they're using.
Oh, okay.
But I mean, how long was Marshall on the bench?
No, I mean, Brennan was forever.
But it-
Marshall was long. It said in one of the articles that we read for today, Marshall was like 67 or something. But,
It was interesting too, because like Bill said, like Thomas and Scalia are like, you know, currently on the court, but then the liberals of today aren't, you know, way down here. And like people say the court is moving more to the right and stuff.
Yeah.
Which I
It is really interesting.
That like, you know,
the timing.
Ginsburg and Breyer are up here, they're not down here, so.
Yeah. I mean, it was a pretty apparent chart. I mean, it was like the most decisive, I thought. And that's kind of what I fixed.
which table are we looking at?
Table 3.
Okay.
And then in the article though, they were like, O'Connor's clearly, they said like there were problems with the table, like, because someone, O'Connor was clearly like more liberal than someone that the table didn't reflect, but I
Yeah.
don't understand all the math, so I couldn't really get.
Well, it's hard because when you start breaking it down to, you know, a matter of numbers, there's a lot of nuance
Yeah.
that gets lost in there. O'Connor, you know, had such an important role in
The
so
type,
many.
is the type of cases, the
And-
specific cases.
Yeah.
And from, I mean, my own experience of collecting this information, it's like, the more data sets you have, the more gaps you have for, like, there's no information. So it's like, it starts to skew some of the data. And so it's like, even though you know, like, point blank, like, that's not right, like,
Yeah.
sometimes the mathematical numbers kind of, they align with our opinions and are like, our observations, but,
Right.
and sometimes they completely just look like blasphemy, so.
So, and it's interesting to think about, like, so how useful is this type of analysis, right, and to whom? And what would your judges think
Yeah,
about this type of approach, right?
yeah. This almost goes back to, the first discussion of like baseball versus,
Yeah.
law, and then like
Yeah.
computer analysis versus,
History,
human, like
narrative,
human,
yeah.
It's like if it is right on, then it's like almost kind of an argument to like just, let computers and numbers decide our legal system.
And why is that, I mean, I'm sure that would be very offensive to a lot of people, that idea, and why? Why is that offensive?
Well, I think that humans are in control of computers, but this would be shifting that to
Uh-huh.
computers controlling humans. But I'm kind of a paranoid, judgment day kind of guy. Yeah, so that's pretty sure. I have a couple little wrap-ups, and before I pass on the torch to you, but they suggested other like just future research subjects, and so and you kind of touched on it too with like the sliding scale. They were able to determine that the judges do change ideologically throughout their term, but they didn't test whether, was that, like, what was causing that change? Was it, society itself? Was it the party that was changing? Was it the judge who was changing? So it's like, in this comparison analysis, they couldn't really pinpoint what was driving that change in ideology. So that was kind of one thing, and then they just suggested kind of off the cuff a couple research topics. So if everyone ever wants to be published and write on something, here's some topics.
Make your own formula.
Yeah.
Little smoke and mirror.
Yeah. So media, some of the databases were based on media speculation, and that's kind of how they determined conservative versus liberal. And so it was like media speculation of federal appellate judges. Whether or not this media attention helps with promotion to the Supreme Court. And so if someone is possibly nominated to the Supreme Court, do they begin to dissent more? Do they begin to attract more attention to themselves and kind of almost make it a political move in order to go from that, circuit court judge to a Supreme Court judge? Would be kind of an interesting study just to see what lined up there.
This is kind of unrelated, and I don't really feel like numbers would get at it, but thinking about Justice Thomas and his confirmation, his very modern, confirmation process, and whether the confirmation process itself fed into his judicial persona, like is it kind of constitutive of how someone behaves once they get the bench?
It was interesting too about the media. They said that they thought senators had more information about potential nominees, like political leaning, versus what the media coverage said. And I was like, oh, that's weird. That seems like kind of anti-democratic.
Yeah. I mean, they touch on it a little bit, and it kind of does make you think pretty quick, like separation of powers, like how much communication and information sharing is going on, like at some of these higher federal positions. But and if people like that ideology too, like if they're pairing up with certain senators and everything else, but hopefully there's enough separation, checks and balances, so they don't have to worry about that. And then a second topic was looking at the number of amicus briefs that are filed in a case, and as a predictor of one, how important is the case, and then also just like likelihood for dissent, whether or not we'll see more dissent in that case than we would in others. Just a couple other kind of research.
That just makes me think something I wanted to tell. That's really great. Thank you.
Yeah.
2 websites you guys might want to go to. Where, for example, because I was looking at this today, you see the number of amicus briefs filed in the Barry case, which is really astounding. And one of the big things about filing an amicus brief is, can you say something on the first page that will make the court actually read it, right? Which I think is pretty hard to do. A lot of them are just pretty useless. But the SCOTUS blog and then Equality on Trial, which used to be Propagate Trial Tracker, I would just pull it up every day and kind of see what's going on. They have analysis of the decisions pending before the court, and so Equality on Trial is an advocacy website. I should clarify that. That is for folks who are advocating for, Prop 8 as being unconstitutional. So, and honestly, that's just the one that I checked, but there might be other ones out there there are other ones out there that present the opposing view, but SCOTUS log is academic, but pretty neutral. But it's a good way to stay on top of what's happening in the cases, both in terms of the filings that are happening and then, because on SCOTUS log, you can go and look at every single amicus brief. You can just click on the link, so it's a pretty good resource. So great, okay, Kira.
I have a PowerPoint, so can I, because mine kind of lent itself to pictures.
Yeah, that's awesome. Okay, so.
I don't need to do that. I can just pull it up on my computer, but I'll just swing around here.
Okay.
I don't need to do the whole projector.
Okay.
It's just fun back.
Oh, that's cool. I did my first PowerPoint ever for my job talk last semester. It's hard to do a good one. So I'm going to scoot over here so I can see.
It just let me do this. Okay, so my article was called "A Principled Approach to the Quest for Racial Diversity in the Judiciary." Can you guys look that?
Yeah.
So the article argues that we should strive for greater racial diversity in the judiciary so that the judiciary reflects a cross-section of the community. So this is drawing from when Professor Pollvogt had the spectrum up on the scale, a lot of critical race theory analysis. And the article argues that racial diversity in the judiciary will serve to enhance the system's legitimacy, and it'll allow diverse perspectives and experiences to be represented on the bench. So the article talks about both the U.S. Supreme Court and the Federal Circuit, but I mostly just focused on the U.S. Supreme Court since that's, we know the justices and they're more in the limelight. It's easier to talk about. So this is the U.S. Supreme Court in 2004. The article is written in fall 2004, so prior to Justice Sotomayor's appointment and Justice Kagan. So just a visual. This is the current U.S. Supreme Court, so it includes more women and the first Latina justice. So the first African-American justice was Justice Marshall, appointed by President Johnson in 1967. And then the other racially diverse Supreme Court justices are Justice Thomas and Justice Sotomayor. So the article mostly talked about racial diversity, but it did talk about other types of diversity, so I'll talk about that a little bit throughout my presentation. As of today, no Asian Americans or Native Americans have ever served on the Supreme Court. At the time of the article in fall 2004, there were no Native Americans serving on the federal bench, few African Americans, Latinos, and Asian Americans. I don't know if that's true today, but I do know that of all those groups, the numbers are still very few. So why is it important to have a diverse judiciary? Some of the reasons the article presents are to introduce new perspectives that are traditionally absent from the judiciary, for the judiciary to represent the population in our country, the fact that judges filter the facts of cases through their own personal lenses, and public perception of legitimacy and public confidence. So the article argues that decision-making bodies that are homogenous and not representative of a cross-section of the community appear illegitimate. Professor Sherilyn Eiffel argues that a racially diverse bench can introduce traditionally excluded perspectives and values into judicial decision-making, and that racial diversity on the bench encourages judicial impartiality by ensuring that a single set of values don't dominate judicial decision-making. So
it kind of assumes, we go back to our other discussions, it sort of assumes, the whole voice of color idea assumes kind of a realism.
Right.
And they talked about sort of the thinking machine versus, but you're kind of already a step with assumptions that, but we assume that in our process, right? I mean, like with the Supreme Court nominations, like why do we ask people? what their political leanings are if we are going to pretend that that doesn't make any difference, or...
Yeah, and so like you're bringing up, you know, the opponents of the people who disagree with Professor Eiffel and disagree with these ideas of a diverse judiciary would argue that people shouldn't be using their own personal experiences and they should just be applying the law and applying precedent. And so I feel, to me, it seems like a more formalist argument that it shouldn't matter what your race or your gender or sexual orientation status is. We should all just be applying the law.
So that's interesting, because from a formalist view, it doesn't matter who's on the bench, so it might as well be all white men. Mm-hmm. Or what I hear you saying, maybe on the other side, is from a formalist view, we shouldn't, because there have been concerns expressed, for example, the motion to recuse the district court judge in the Prop 8 case because he was homosexual, right? There are other views that, you know, people, that sort of idea of the unmarked category, right? If you're a marked category as a racial minority, woman, sexual minority, that you have an agenda, whereas, you know, the unmarked category of white male doesn't have an agenda or whatever.
Yeah, I thought that was really kind of offensive in the article, the whole argument that like the black judge couldn't hear the discrimination case, which is like, so if it's a white defendant, a white judge could never hear it discriminate. Like it's so illogical.
Well, it's a lack of symmetry in terms of assessing identity and the meaning of identity.
So I actually have all that later in
This is great.
So just to remind you, the voice of color from the critical race theory is that people of color have different perspectives or may have different perspectives than their white counterparts on certain issues. There's obviously no single voice of color, as we saw, as we all know from knowing about the court and then seeing from Wells' article, Table 3, Justice Thomas and Justice Marshall are not ideologically aligned, and in fact, many say that Justice Thomas is the most conservative and Justice Marshall is the most liberal, and they're the only two African Americans ever to serve on the bench. It was interesting in the article, the authors talked about some of the justices that served on the court at the same time as Justice Marshall and their quotes about his contribution to the bench. So Justice Brennan said, Justice Marshall made unique contributions to the court because of his firsthand knowledge of the law's failure to fulfill its promised protections for so many Americans. And Justice Byron White stated that Justice Marshall characteristically would tell us things we knew but would rather forget. And he told us much that we did not know due to the limitations of our own experience. So it was interesting to have, these quotes from justices on the highest court saying that it mattered, and especially seeing some of the cases that came before them. So although Justice Thomas is conservative and holds a perspective that many African Americans might disagree with, he also has a distinct African American voice. For example, in Virginia v. Black, he observed in his dissent that cross burning has historically been used by white supremacists to intimidate African Americans, and he wrote passionately in opposition to affirmative action in Grutter v. Bollinger and discussed how he personally felt stigmatized by affirmative action. So that's an interesting perspective. He's from the rural South, and he experienced, so coming from the rural South as an African American, he had those personal perspectives. So when he characterized the KKK as a terrorist organization, that was especially powerful as a label in our post-9/11 world. So just getting away from racial diversity, Justice Brandeis was the first Jewish justice, Justice O'Connor was the first female justice, and Justice Ginsburg was the first Jewish female justice, and Justice Kagan is the fourth female justice. I thought I had to put her in because there's still so few women on the court.
Oh wow,
Yeah, right. A lot of women in the last few years. So Justice Ginsburg asked if there was a Jewish seat on the court, which was interesting because between Justice Brandeis and Justice Ginsburg, there's been Frankfurt or Cardozo. So Justice Ginsburg's question kind of acknowledges that the court is representative of the country, similar to a political body. And it kind of begs the question of whether there should be seats for different demographics. And on the opposition, some have argued that now that our court is more diverse, the white males aren't adequately being represented if you're looking at, a pure numerical standpoint. Justice O'Connor co-authored a 3-justice opinion reaffirming a woman's right to an abortion in Planned Parenthood v. Casey. Justice Ginsburg is well known for her career as a women's rights lawyer, and she's continued her involvement with the National Organization for Women while she's been a sitting justice, which has been really controversial. So that kind of reminded me of our discussion a few weeks ago about judges and justices' roles as clerks or roles in the political arena, and our role as clerks, and if we'll be limited. So that was interesting. Footnote 72 of the article links to a New York Post article about the justices' possible bias and the media attention surrounding both. That had a conservative slant, and so it was arguing that when Scalia does something really conservative, everyone jumps all over him, but Justice Ginsburg is part of now and nobody talks about it. So it was just kind of interesting.
Well, there's some difference in terms of how they operate, because Scalia is so
Bombastic.
Right.
spilling the beans all the time.
Yeah.
But that's really interesting.
Yeah. So Justice O'Connor has written about gender diversity in the court, and she mentioned that a wise man or a wise woman would reach similar conclusions in the same case. So that was really interesting. I didn't know about that. And it's interesting given Justice Sotomayor's confirmation hearings and the controversy regarding her wise Latina comments. So if that was, back in 2009, it was a big point of controversy that people who believe that your race or gender or sexual orientation or religion shouldn't affect the lens through which you look at the law. A lot of conservatives criticized her for using the phrase wise Latina. So she often discussed her quote-unquote Latina soul and explained how even the traditional dishes of her Puerto Rican family shaped her views. She often said she hoped those experiences would help her reach better judicial conclusions than someone without such a varied background might reach. The line that she said was almost identical every time. I would hope that a wise Latina woman with the richness of her experiences would, more often than not, reach a better conclusion. That sentence, or a similar one, has appeared in speeches she delivered in 1994, 1999, 2002, 2004, and 2001. She also concluded the phrase when she said, reach a better conclusion than a white male who hasn't lived that life. So Republicans said that that was racist, and there was a lot of outcry over that. So I just wanted to open this up for discussion. Do you guys remember this controversy? What were your views then? Have they changed since then? And did reading this article change your views at all?
I thought when I first heard about that, I just thought, you go girl. And then I recently saw an interview with her, I think it was like Jon Stewart or something.
Oh, Colbert. She was on Monday.
She recently released a memoir, and he was asking her questions about it, and she was saying how having a position on the bench kind of isolates you from society to a certain extent, and that the reason she wrote the memoir was to sort of leave a note to herself that she can look back to in the future about the person that she is and the person that she was before she got on the bench, and remember those experiences because it made her who she was. And so I thought that was really fascinating. Race aside, just an interesting comment on how being on the court can kind of separate you from the everyday experiences of most people.
Mm-hmm. Well, it's just a self-awareness that I think is not, in some ways, that's the idea of being behind the robe, and behind the closed doors of the chambers, and that judges somehow to have authority need to be really inscrutable and almost non-human. Mm-hmm. And she has obviously, again, regardless of her race identity, though likely informed by it, a very different philosophy about that relationship. Mm-hmm. It's pretty radical, really. Yeah.
Anyone else?
Thomas does he still do his RV trips across America? I think in their,
don't they go together?
I don't know. It is big in their big break. I think.
Did you read about that? No.
I thought Thomas and his wife.
Maybe it's Thomas.
I think Thomas and his wife travel across the country in an RV every.
As an effort to
be aware just sort of to sort of be a regular person out in the world a little bit.
I was reading about that I learned that you can overnight park an RV at any Walmart in America, which is really a tidbit.
You're like, this is Thomas.
It's the policy, which is very
That's very interesting.
I guess when she said it, I didn't think that much of it. It didn't seem like a real controversial thing. I don't know. I guess if you're saying my experience makes me more wise than someone else, or I'll come to better decisions than someone else because they aren't of my race, that seems a little weird, you know?
So what's the best defense of what she said? Because she probably wouldn't mean that, right? I mean, that would be kind of ham-handed. Though I think
Well,
that's how she's interpreted is.
So is that like parenthetical on the end of it, the
Well,
then a white male?
No, she said that. I mean, she said, I would hope that a wise Latina woman with the richness of her experience would more often than not reach a better conclusion than a white male who hasn't lived that life. But I think that her defense of that would be that we've had 9 white males for hundreds of years, so it's might be helpful to have some diverse perspectives to bring that richness of life to show the other side, when a lot of litigants aren't white, rich white educated males.
Do we know what question she was asked and what that was the response to?
That was during a speech. I believe that was during a speech prior to her confirmation. I don't think she said that during. I think it was prior to her confirmation.
No, it was.
Yeah.
I mean, it was just kind of a theme. I mean, I think prior to her nomination, she embraced being a woman of color, and so she talked about her experiences growing up in New York as a Puerto Rican woman, and so I mean, she did at DU. I mean, it was more politically correct because she's a sitting justice.
Right.
But she talks about her background, and so I think these are just things she said in speeches talking about being a woman of color. And then when in her confirmation hearings, the Republicans were like, what do you mean?
Yeah. So there's a lot of interesting stuff in there. I mean, I think one is just looking at the way we sort of, this is a loaded phrase, but whitewash judges, right? So they have this identity and they can speak freely about issues, and then sort of like, people really shut down what they're willing to talk about and are not as provocative or whatever. But another way of, just kind of as you were speaking here, I was thinking about these categories and threw those up on the board there, but she is not, I think the best reading of what she said is that she is not claiming the superiority of being a Latina. She's claiming the superiority of having experience, of having life experience and consciously incorporating that into her jurisprudence versus, and again, I think this is I see this both in Plessy and in Bowers versus Hardwick, these sort of blind spots about other humans, right? And so it's sort of advocating for a more humanistic approach maybe to judging, which is kind of fraught, I think, in a lot of ways. But also increased awareness, and that's a separate issue, right? Of knowing that one is drawing on one's own experience, and that really being lacking in some of these more problematic decisions. I also wrote there about double consciousness, and that sort of idea that, there is this sort of idea that people who have had to navigate being both an insider and an outsider have a kind of mental flexibility that is a sort of skill that people who are really firmly entrenched within a particular milieu don't necessarily have.
That was actually something that came, when I was reading this, I struggled a little bit with some of the concepts, but I think the one that resonated with me the most was the immigrant's perspective, because in terms of being literally an insider and outsider, and also the types of cases that deal with language barriers, education, immigration policy, etc., that to me was the most convincing argument that they had for how a perspective based on race most likely would be compelling to have on the bench.
I mean, I saw like the 60 Minutes episode with Sotomayor, and she went down to like the Bronx, or like the project she grew up in, and she knew people by first name as she walked down the street, and it was like, I think that's the perspective where she's like, I've lived this, and a lot of Supreme Court cases are dealing with like civil rights issues, not necessarily like business white American male issues. So I think it is a lot, that experience and like knowing kind of that situation. I mean, I don't think you'll see a Justice Scalia down on the Bronx anytime soon.
Well, so the courts oftentimes are protecting the rights of the disenfranchised, and then the question is the traditional model of the United States Supreme Court justice, someone who has sensitivity or awareness of the experience of the disenfranchised. I think the race is doing a lot of work in this article and this theory, and I think that's kind of the toughest question is, when is race a proxy? When is race a proxy for different experience? And this is actually coming up in the affirmative action case in Fisher versus University of Texas as well, is kind of what does racial diversity really represent? Because we kind of assume that it represents different experience and that it represents in particular maybe a different type of class experience.
Right.
Sotomayor went to Yale. I mean, right, there's different types of, different measures of diversity, and, arguably, having a different experience prior to becoming part of this sort of elite, the super elite, one would still carry that with one in one's professional career, but it's an interesting question, kind of what work is race doing in this whole discussion.
That actually, the different types of diversity came to mind for me as I was reading this too, because then I started thinking about economic diversity, I started thinking about age, I started thinking about people who have been through the criminal justice system as opposed to not. And I know it would be a difficult argument from a credibility perspective to say that you should put someone who's been convicted of a felony on the Supreme Court, but like experience with the institutions that you are judging, and that to me is another way of defining diversity. This article is obviously based on race, but
I think
lots
there's
of diversity there.
Yeah, there's so many different aspects of, I think even though the article focuses on race, it does kind of bring up like that some of these ideas can be applied to all other categories.
Well, and that, for me, and among the arguments, because I think racial diversity can be a proxy for diverse viewpoints, but race cannot be a proxy for a particular viewpoint, and the article acknowledges that with talking about Thomas and Marshall. But I think, to me, the most compelling idea of justification for a racially diverse bench is really the legitimacy point, right? I mean, the process of sort of ensuring, there's a separate initiative to get diversity of viewpoints that maybe is more acknowledged or less acknowledged, kind of depending, but that, I think the legitimacy, the public legitimacy piece is really compelling because there's such an immediate sense, if it's an all-white bench, that this represents only one segment of society, and that's problematic.
So this is what Bill was talking about earlier. Judge Higginbotham rejected the claim that he was biased because he was African American. So you can read this quote. I won't read it to you, but. So he asked, just at the end, he asked a threshold question which might be inferred is, since blacks, like most other thoughtful Americans, are aware of the sordid chapter in American history of racial injustice, shouldn't black judges be disqualified per se from adjudicating cases involving cases of racial discrimination? He answered no, and many other judges of color have had to face similar disqualification pressures. And like Professor Pollvogt alluded to earlier, no one can really say that this has never happened, but the authors of this article are not aware of any disqualification claims made against white judges based on racial bias, resting solely on their race.
That would be a very interesting kind of
That'd be
specialty to
great.
develop.
Yeah.
Motions for disqualification or recusal. Aimed at
Throw it out there anytime.
So judges must make decisions based on the law. Judges aren't machines who formulaically apply the law to the facts. So they have a degree of discretion. They take positions and decide cases in accordance with their ideological preferences. So some scholars argue that that's important to have judges who have different ways of looking at the world on the judiciary. So, can you think of a similar recent example in which a judge's ruling was questioned based on his demographics?
Do you have something in mind?
I do. If you have other ones, that's great too.
We're not back to Prop 8, are we?
Yeah.
Okay.
Yeah. So it's what Professor Pollvogt said earlier. U.S. District Court Judge Walker. So the Court of Appeals overturned Prop 8 and ruled that Judge Walker, who ruled against the 2008 ballot measure banning same-sex marriage, was not obligated to step away from the case because he was in a long-term same-sex relationship. The panel found that he based his ruling on sound law and logic and cited that it was unreasonable to presume a judge could not be unbiased simply because he or she might one day be affected by the ruling. So that's just an example of someone in a minority group being questioned.
Go ahead, sorry.
When generally people who are in the majority groups aren't questioned, like, well, this affects straight people and you're straight, so maybe you should recuse yourself.
Yeah, that whole unmarked category thing again, right? Because one of the foundational arguments of proponents of Proposition 8 is that Prop 8 protects heterosexual marriage. So, yeah, a heterosexual judge would be just as directly affected, presumably.
I have a procedural question about that. So I know that you can file a motion to request a judge to recuse themselves, right?
Mm-hmm.
Is there a motion filed?
Mm-hmm.
Can we read it?
Sure.
I'd really be curious to hear what their arguments are.
No, that's a great idea. Do you want to track it down?
Sure.
I can do it, but you know
No,
what?
I'm really happy to.
Yeah. So if you go to, you want to just go to well, it could be a couple different places, but if you go
Look
to
on
the,
Westlawn next for filings, maybe, or what were you going to suggest?
well, I was thinking that, there's the brief in the Ninth Circuit on the issue, and then there's the original motion itself in the district court, which would be in the district court docket. I'm not as familiar with looking through district court.
Similar stuff you can find on Westlaw.
Yeah, sometimes you can see
Multi-case, they might have some.
Yeah, like the brief.
Or you could even, I bet if you Google it, I bet someone out
Yeah.
there, like
What's the actual name of the case?
Airbnb.
it was Perry versus Brown, then, I'm sorry, it was Perry versus Schwarzenegger, then it became Perry versus Brown, then is now Perry versus Hollingsworth, or Hollingsworth versus Perry. But you could, yeah, probably Google recusal motion, Judge Walker, Perry case.
So some issues involving Latinos and Latinas likely to come before the courts are voter-backed initiatives that discriminate based on immigration status and language proficiency. So that made me think of this past presidential election, all the voter ID laws that discriminated disproportionately against certain minority groups, including people of color, elderly people, and veterans. Bilingual education, driver's licenses for undocumented immigrants, legal status of Puerto Ricans, and racial profiling of Latinas and Latinos. So this article focused a lot on the lack of having a Latino or Latina justice and all of the issues that are coming to the forefront now. And we do have Justice Sotomayor, so we'll see how that plays out. So the article drew a parallel to diversity on juries with diversity in the judiciary, and it asserted that it's a generally accepted view that diversity in juries is a good thing. It's good to have our juries be a cross-section of the community. A famous example is the Rodney King case where white police officers brutally beat Rodney King, who was African American, and all-white jury acquitted them, and then which led to the 1992 LA race riots. But some of the rationales of having a diverse jury is improves the quality of jury decision-making, enhances the jury's political legitimacy, and serves to educate jurors about the importance of civic duties. And this doesn't extend just to racial lines. An all-male jury trying a woman could be problematic, a middle-aged jury trying a youth, etc. Which also raises the point that Allison brought up earlier. A lot of people who have criminal backgrounds aren't allowed to serve on juries, so that's unfair when it's all people who don't have criminal records judging their peer who may not be in the same position as them.
There's also the idea of the death certified jury, right? So that you can't serve in a death penalty case if you don't believe in death penalty.
Right, yeah.
Which is,
Come to the conclusion of
yes.
Yeah. So I mentioned the LA race riots. Many people in the African American community believe that the all-white jury didn't represent their community or the country's community as a whole. Judge Reinhardt, a Ninth Circuit judge, wrote that Presidents Reagan's and Bush judicial appointments have ensured that the federal courts will not be representative, and said they are a bastion of white America. So that was
Judge Reinhardt!
pretty progressive quote coming from a circuit court judge.
He's seen as one of the most out there, and he's the one who authored the Ninth Circuit Perry decision. So you'll be familiar with him.
So why do you guys think there's a generally accepted view that juries should be diverse, but this view is not as widely accepted for judges?
Because they're not people; they're just big brains.
I think because juries are randomly selected, and so they're just by default supposed to be, well, not randomly selected, but more randomly selected than judges, and so they're supposed to be just by default more representative. And I think people tend to think of the bench as more merit-based, which history indicates as a way of theoretically weeding people out, whether that is right or not.
Well, aren't they choosing from a smaller pool too? I mean, juries, you don't have to have any particular qualification, generally, but they're in law schools, and people who are attorneys, whatever their race is also indicative of what the judiciary represents as far as race.
I mean, these are all like these are presidential appointments too, versus like being voted in by your constituency or like representing your core group of people. So
those are like all the logistics, but like when there is a minority, no matter what group, if it's race or sexual orientation or gender, like for example, for Sotomayor, there was so much pushback, and it could have been because she was outspoken and she did talk about her background and she had used the phrase "why is Latina," but there's this like, when the opportunity is presented, there's like a pushback, like no, we should be completely race blind and just have our bench be merit based, even though Sotomayor graduated at the top of her class at Yale and stuff. But
well, I think it's similar to some stuff with affirmative action, the idea of, well, if we consciously think about race, especially the Supreme Court is this tiny representative body, that somehow race will be given too much weight, or that it's improper to think about race at all, or that, as we were talking about earlier, there will be too much diversity on the court, that all of a sudden you'll have white males in the minority, and that's a really radical change. And I think it also has to do with that unmarked category thing that, diverse candidate is seen as having an agenda. So that people react poorly to that.
The public's more realistic about the process too. They realize, you just have people walking into a room who are going to make a decision. And I think through the law school process and stuff, we sort of get inculcated into this believing in the law as a system, and where I think we have this different view of judges and how they should be than sort of the general view. Like if you took non-lawyers and stuff, I wonder if they'd have a different take on judges, but I don't remember from the article if they differentiated between like what people in the legal field thought about diversity versus outside the legal field, but I had the sense that the juries, when they were talking about the juries, it was more like the public wants to see a diverse jury, not an all-white jury. Mm-hmm. But then when we're talking about judges, we're talking about kind of the legal academy, and we sort of believe all of these things. We have this faith in the system that...
Or like I think as far as confirmation hearings, it's like the senators who may or may not be within the legal community, but in theory are supposed to be representing, the wishes of the people, whether that happens or not, the public.
I was going to throw one other thing out there, which is just that, I don't know the extent to which you all have experienced this as law students, but I think advancement in the legal field is very much based on mentoring, or is a nice way of putting it, personal patronage is another way of putting it. And so because there's so much dependency on that hierarchical relationship, I feel like advancements in diversity are don't proceed as quickly maybe as in some other fields. Right, you don't have these sort of prodigies who really prove themselves on their merits. It's about that connection to someone who's from the prior generation or whatever.
So just the article talked about limits on juror eligibility, which kind of can be extended to limits on the bench. So immigrants aren't allowed to serve on juries, although if an immigrant is involved in a civil or criminal suit, she goes before the justice system, so it's not her peers. English language proficiency, so the obvious argument against that is it's difficult to translate, but the article questions whether the costs of limiting juror eligibility to English speakers outweigh the benefits of the system as a whole. That maybe we shouldn't just say, oh, it's difficult and dismiss it, but in our democratic system, maybe try and get translators and get people who don't speak English as their first language to be able to serve on juries, and then felons. So there's the racial aspect there because of the racial disparity of people in prison, and then racial profiling, police targeting of poor neighborhoods of color. So there's, because of many systemic things in our society. A lot of people of color do go before the court systems, and then, you know, maybe their peers aren't serving on the juries. So can you guys think of any informal limits for judges that might preclude diversity? So not just racial, but all types on the bench? So we've kind of thrown some out already.
Well, I mean, yeah, if you think about, you know, places like Harvard and Yale as being where so many of the federal judges come from, and those schools really pride themselves on sort of tradition and sort of conserving the way that pedagogy has happened. You know, Yale, they don't have grades. And so your advancement is really determined by your relationship, again, with members of the faculty, et cetera. I just feel like that plays, I feel like legal education, the dynamics of legal education advancement in the legal profession plays a big role in that.
And so going off that, one of the ones the article mentioned was previous judicial experience. So it's, you know, it's like if you get appointed to the bench, you know, either by merit and who you know, then, you know, if you're already a federal judge, then maybe it's more likely for you to be elevated to a circuit court or to the Supreme Court, and graduation from an elite law school, even if the number of diverse candidates in all aspects of diversity are, you know, increasing through all law schools. The Supreme Court justices certainly, and then even still the federal judges are coming from, you know, Harvard, Yale, Stanford, Columbia. And then there's also like legacy admissions.
Mm-hmm.
I mean, I know people, I mean, the other argument is affirmative action, but there's legacy at a lot of law schools, which because of segregation and the history of our country affects certain groups.
So the effects of what happened in prior eras kind of persist more maybe than some other, yeah.
So we've talked about this briefly too, but a lot of people say, what about merit? Shouldn't our judges just be appointed based on merit and not about other factors such as diversity? But in reality, few appointments are made both based solely on merit, like Professor Pollvogt has talked about. There's a lot of networking, and judges who represent minority demographics who have been appointed have comparable educational and professional accomplishments to their counterparts. People raise the issue of affirmative action, but you know, it's kind of like the stuff we've seen with President Obama. And even though he was the editor-in-chief of Law Review, people still wonder if he deserved it and demand to see his report cards and stuff. So.
And that's fascinating, I think, the idea that promoting diversity and promoting merit are necessarily in conflict. That sort of assumption, I mean, it's really pretty amazing.
Mm-hmm. So, concluding thoughts is that, you know, it's not necessarily that race equals diversity equals better. I mean, this article had a liberal slant, and so they asked the question, would you, probably talking to their liberal friends, not conservative friends, would you rather have 9 Brennans or 9 Thomases? And liberals would probably say 9 Brennans. So even though he's a white, educated, you know, able-bodied, straight man, and Justice Thomas has, you know, diverse racial experiences, you can see how their ideological, you know, how their ideologies lie. Mm-hmm. So there's a difference between aesthetic diversity and, you know, different perspectives. Although Justice Thomas, even though he is very conservative, has brought different diverse perspectives to the bench, as we talked about with Grutter in Virginia. Yeah. So that just kind of reiterates there's no voice of color, and you know, although most African Americans tend to be liberal, that's not to say that African Americans don't also, you know, prefer Thomas over Marshall. Mm-hmm. So then my last question is just, can you think of any experiences in your background that might affect your views on certain types of cases? And it was interesting, in one of my clerkship interviews, it wasn't this question, but the judge asked, are there any cases where you would not be able to be impartial? Mm-hmm. So like, you know, if it was, I don't know, a murder case or something, and a family member had been murdered. And so I thought that was an interesting question.
It's like a more detailed question.
Yeah.
Stand up and give oral arguments, like
I'll just throw out there that I hope nobody's stressed about, I mean, the civil business class is not meant to, you know, we're going to do what we need to do. We're going to get through everything we need to get through. So I hope people aren't stressed, you know, because what we're doing every day is shifted a little bit. Because obviously we're going to do the procedural and stuff next time. But that's fine. But I did, you know, I was a feminist sort of person, and you know, when I was younger, I mean, I'm still a feminist, but that was a lot of what I studied and sort of did activism around, a lot of domestic violence work and things like that. And there was a case that when I was a staff attorney at the 10th Circuit where the criminal defendant was a woman who had been abused by her husband, and she waited to kill him until, you know, when he was asleep or otherwise disabled. I forget exactly the scenario. And the issue was whether it was ineffective assistance of counsel to not present expert evidence of battered woman syndrome in the case. And so the judge that I was working with was inclined to affirm the conviction, and I was like, I think this is a problem. I think this merits further investigation, and you know, kind of develop the arguments a little bit more on that issue, which I don't think I would have necessarily done had I not had that kind of activist background, you know. So for me, that's something that pops up as a case where my experience as a person definitely filtered my assessment of the merits of the arguments being presented.
Was your judge receptive to you?
Amazingly, yeah. He was a very conservative judge, and you know, I mean, it was that sort of thing of the presumption towards affirming in criminal cases. So yeah.
I know. I mean, I went to a clerkship like information session one hour, and Dean Smith talked about how when she was clerking on the 4th Circuit, I think, that I mean, she was open about her sexual orientation to her judge, and a case came up, and she talked about her experiences, and the judge was like, well, I hadn't thought about it that way. I mean, I feel like she could definitely tell you that story better than I did, but I mean, that really struck me. So if you guys are interested, I'm sure she could be willing to share.
Maybe we'll have her as a guest speaker.
Yeah.
Yeah, her talking about her clerkship is actually great.
Yeah.
Really interesting stuff. But then also, you know, we all know that she has a lot of chutzpah. Yeah, no, I mean, not everyone is going to share their experience, but that's also, you know, part of, you know, I think her personality and that she brings to that situation is the willingness to share an experience that might cast a different light on the situation.
I mean, it's interesting to me that faced with that question, you kind of go back to a marked category, like, you know, everyone's experience affects their view of every case. I mean,
I don't sit there and think, like, how does my white privilege affect?
Right. I mean, it's,
you know, how does growing up in the middle class affect it? I mean, that's a very fair question. Yeah.
I mean, I think it could extend to other things, like, you know, if it's a rape case, I mean, your sister was raped, you know, you could be a male or something, or if you were robbed by someone of a certain group or something, but yeah, it does tend to. But
so it's like, well, people said this about Kate Murphy back in the 90s when her book came out. She was like, sort of saying, well, there's not really this epidemic of friend date rape or whatever on college campuses, and people said, well, maybe your friends don't tell you because they know that you're not receptive or whatever. But that again, with the marked and unmarked category, you know, let's say you're a person who doesn't know anyone, or you don't know that you know someone who's been raped.
yeah, I mean, then it's a bias too.
And it is
I mean,
biased.
it's just
yeah. I mean, class bias, I think, obviously plays a huge part, because even though we come from different class backgrounds when we come to law school, we kind of become of one class by virtue of going to law school. And obviously, there's, you know, caveats aplenty about that claim, but you know, once you are empowered to sort of manipulate the levers of justice, you're in a different position than somebody who, you know, is maybe a criminal defendant in a trial or what have you. I mean, I've had students who have criminal backgrounds, and that you know, it's kind of a parallel to being closeted. It's something that actually does influence their perception of things that they're learning and their experience in law school, but you know, it's so taboo to talk about it that they just kind of keep it to themselves.
I think I would argue that our ignorance is probably more dangerous than knowing that you're kind of an advocate for a certain point of view. You know, if there's some whatever group or experience that you don't know about and you have no idea that you don't know about it, I think that bias goes straight to your conclusion a lot faster than if it's like, I have this background, I may be slanted this way, and that figures into your thinking in a more conscious way.
Well, I think this is a really nice arc in terms of where we started talking about ethics and then looking at Plessy and Bowers and then formalism and realism and your discussion of this article, because, you know, it's sort of, we all have identities, and the sin or the mistake is to not be cognizant of how that affects you, right? So to not patrol for your own biases. And I think that it's that lack of self-awareness that marks, you know, what I think of as the worst decisions of the United States Supreme Court. So that's an interesting thread, kind of going through all that.
It's kind of just like framing the question in the reverse, like, should we have like diversity on the judiciary, or should we just not have lack of diversity on the judiciary, right? Because if we have...
Well, that homogeneity,
yeah.
You just have to have an anti-homogeneity agenda, because we know homogeneity is not good for the thought process or the discursive process. That's a really interesting point. Wonderful. Well, that great discussion, and I'm really glad that we spent the time to really focus on what you all had to say about interpreting the articles that you read. So thank you so much for your work on that. It was really, really thought-provoking. And these issues are going to be echoing throughout our work on the problem coming up. So what we'll do is on Monday, let's take a look at the syllabus real quick. I leave a lot of cushioning in my syllabus too. So this will be perfect actually, because kind of one of the things we're going to talk about in terms of appellate process is, you know, drafting a judicial opinion, how that works in terms of your work with the judge and what have you. So we'll kind of just go deeper into that. So on Monday we'll talk about all the procedural and jurisdictional issues that I've outlined up here. We'll just go ahead and go over that, and then we'll focus more specifically in on the stages of drafting a judicial opinion. A couple of handouts for you guys here. And then Allison, you're going to find the motion for recusal.
Yeah, I just looked at there's like 500 filings. Because it's going to take me a little while to filter through it.
You might go to one of the advocacy websites.
Yeah.
I would
Someone else
say,
has done that.
Yeah, so it used to be Prop 8 Trial Tracker, but now it's Equality on Trial, and they definitely covered that issue pretty
I found a motion to vacate the judgment on the grounds the judge should have recused himself. I think he maybe told people afterward that he was.
That's correct. Actually, that's correct.
Yeah,
so I think that was
what it is.
I think that was actually the only motion for
so it was
recusal.
post judgment.
So he should have sua sponte recused himself.
Right.
Knowing
He
this.
didn't say that he had a same-sex, but actually stepped down a little bit.
Yeah. Well, I'll pull that and I'll email it to everybody.
Okay. So I'll wait for this for next time. I brought the petition for certiorari and the Perry case, and I just kind of wanted to make the point about the difference between mandatory, obligatory appellate review and then discretionary certiorari review, and the types of arguments that are made and that were made in this case in particular. This is just an interesting essay on the standing issue in the Windsor case, which is the Federal Defense of Marriage Act case. And we're going to be looking, it's just sort of compare and contrast, because the Supreme Court added the standing issue to both of both the DOMA case and the Prop 8 case on its own initiative. So we'll kind of think about the difference between the standing posture in those two cases. And then finally, this is the district court decision in Perry versus Schwarzenegger. And I would like for you to go ahead and try to work through this over the weekend. We're not really going to dissect it until Wednesday of next week. But, and then we'll talk about the sort of strategic significance of this. I mean, the findings of fact are extremely lengthy, right? So that's interesting.
me just type.
Because the original copy that I have was like from the day after it was handed down. And the findings of fact came before the conclusions of law, but it looks like,
And here's the findings of fact, insert to line 53.
yep. That's funny. So, do you need to know the findings of fact in great detail now?